Hello everyone and welcome to this video tutorial in which we're going to be looking at how to apply the defence of consent in criminal law to an A-level exam scenario. And the defence of consent is a really interesting defence because it may operate to defeat an element of the actus reus of a crime and therefore render the action lawful as opposed to unlawful. So, for example, with the offence of battery, we know that that requires the application of unlawful physical force. So where a person validly consents to being touched, the application of force is lawful. But the defence of consent doesn't apply to all crimes and can never be used for the offence of murder. If you do need a little refresher on the law of consent of all the key cases and the principles, I do have another video on my channel dedicated to that. But in this video, we're going to be looking at how to apply those cases and principles to a scenario question. So let's get on with doing that. So here's the consent scenario that we're going to look at in this video. The facts are these. Anne asks her boyfriend Joe to brand the letter J on her upper arm. She is keen to show off how proud of Joe she feels. Anne's burns require hospital treatment, and you're being asked to advise Joe on his possible defence to a GBH charge. So notice that this question is asking you to advise our defendant Joe on his possible defence. So really important that you're reading your exam questions carefully. Some students in a rush, in a panic, might see GBH there and start applying the law on GBH, which you wouldn't be getting credit for because the question is asking you on the defence. And notice as well that this question isn't telling you to apply the law on consent. It's giving you a clue that it's a defence that it wants, but you would have to determine from looking at those facts that it's consent that you need to be applying. And hopefully looking at these facts, the fact that we've got the mention of branding and that Anne has asked for the branding to occur, that consent would be jumping into your mind immediately. That looks like a case that hopefully that you're familiar with, the case of Wilson. And scenarios will often do that. They'll often give facts that look similar to a case to help jog your memory and to get you thinking about the law that you should be applying. So let's look at what steps you should take in order to get a good answer to this question. Steps that you should take to tackling a scenario type question, whether it be a criminal, contract, tort, whatever the area, you should always use the idea formulation to try and maximise your chances of getting full marks. And each letter in the word idea stands for a different step that you need to take. So firstly, you need to identify the issue in the scenario and identify who your defendant and your victim is. You then need to define the area of law you have identified as being relevant. If it's an offence that you're applying, if you were applying GBH, for instance, you would define the actus reus and the mens rea of that offence. However, we're going to be applying a defence today, the defence of consent, so we will just define or give a definition of this defence. We then explain the law using key cases and principles. And then finally, we apply that law back to the scenario. So let's take a look at what that would look like for the Anne and Joe scenario. So on this slide, I've done a bullet point answer to the Joe and Anne scenario, and I've colour coded it so that you can see how I've structured the answer according to those steps that we've just been through. So in red font, I've got the I, the D, the E and the A in idea to show you where I am identifying, defining, explaining and applying the law. Now my answer is very brief and bullet pointy so that I could fit all of this on one slide for you. But obviously in the exam, you need to be writing in full sentences and fully explaining the principles from the cases that you mention. So let's look at the answer then. So I've identified my defendant and my victim and the defence that I'm going to be applying by saying that Joe might be able to plead the defence of consent in relation to Anne's injury. And because I've identified consent as being relevant, that's what I need to define in the second step. So I've defined consent by saying consent is a complete defence which is often used as a defence to the non-fatal offences against the person. So this is particularly relevant for us here because Joe is potentially liable for a non-fatal offence against the person against Anne, i.e. GBH. And it's useful at this point to say what other offences consent may be a defence to. So consent can be a defence to manslaughter, and you could use the case of Slingsby to support that. So that was a really interesting case involving a ring. You might want to watch my other video on consent if you're not familiar with that case. So it can be a defence to manslaughter, but it can never be a defence to murder. And that comes from Pretty and the UK, which held that euthanasia is illegal in our country. You cannot consent to your own death. And the next logical rule to say about consent is that consent must be valid, consent must be true and freely given. And Oleg-Bosia is a case that you could use to say that consent must be freely given, because in that case it was held that submission is not consent. Another case on this point would be Tabison, which again had some really interesting facts. And this was where the defendant was misleading patients in hospital. He was misleading them to believe that he was conducting some sort of scientific research, when actually that was just a front so that he could assault patients. And it was held there that there was no true consent because the patients were consenting to him touching them for medical purposes, obviously not for the indecent behaviour which he was actually wanting to commit. So you can't mislead, you can't force someone into consenting. It must be valid, it must be true, and submission is not consent. Another important rule on consent is that lots of touchings that happen in day-to-day life will have implied consent applied to them. And that comes from Wilson and Pringle, which gave us the principle that in day-to-day life, we are impliedly consenting to, as the judge put it, the everyday jostlings of human life. So if you're getting onto a busy tube train, or if you're in a crowded place and you step into the road and someone grabs you to pull you back from a car, there's going to be implied consent happening there. And this is the point where we need to get into more of the nitty-gritty about consent to minor injuries, which is relevant to Joe's case here. So a good case to start with would be Attorney General's reference number 6 of 1980, and this is where two youths aged 17 and 18 decided that they were going to settle their differences with an argument in a public street. And one removed his watch, the other removed their jacket before they commenced in this fight. And they were arguing, well, we consented to the harm that we caused each other. That's how we decided we were going to solve our problems. And the court held, as you would imagine, as a matter of public policy, a person cannot consent to fistfights resulting in ABH or greater harm, irrespective of whether that's happening in a public or a private place. And the court said that unless it comes with any of the established exceptions of properly conducted games and sports, lawful chastisement, reasonable surgical interference, dangerous exhibitions, cosmetic appearances, enhancements, I should say, sorry, or horseplay. So you can't consent to a fight, to getting involved in a fight, unless it's properly conducted sport like boxing, and it's a public policy rule that you can't consent to ABH or greater. And that was something that was reiterated, of course, in the case of Brown, which I'm sure you remember involved a group of homosexuals who were taking part in sadomasochistic activities. They were not able to rely on the defence of consent. That was a House of Lords decision, again, that was using public policy as its rationale there. You then want to mention injuries conducted in sport, and as long as that the participants are complying with the ordinary rules of the game, then the defence of consent will apply there. But there are some cases that you're going to need to contrast that are particularly relevant for Anne's case, and that would be the case of Wilson and again the case of Brown. They're nice to compare to each other. Wilson is actually really difficult to reconcile with Brown because Wilson was the case where a wife consented to her husband tattooing her. I mean, it wasn't a proper tattoo. He was branding her with a hot knife. She wanted him to tattoo her buttocks, basically, with this branding. And the court said it wasn't for them to intervene in the private matters of a husband and wife, and that consent was valid. Really hard to reconcile that with the case of Brown, other than to say Brown was probably a homophobic decision made, by judges that were reluctant to allow consent to be a defence in those circumstances. So you're not going to have a clear answer, really, as is often the case in law, with Jo and Anne. It looks much more, this situation looks more like Wilson than it does like Brown, but we'll get back to that. You should also talk about mistaken belief in consent and the horseplay cases. Jones is one of those that you could talk about there. So once you've explained the law on consent, you need to apply it back to the scenario, and we've just already started talking about that in terms of Wilson, but let's look at what I've written here. So firstly, Jo has committed GBH potentially, so it's not murder, so he can potentially plead the defence. Anne's consent must be true. It does appear to be true in Anne's case because she doesn't seem to be scared. She seems to know what she's consenting to, so that seems okay. Anne's consent is express, it's not implied consent. She's asking Jo to brand her, as in the case of Wilson. The issue is whether Anne can consent to ABH or greater here, and we'd refer to AG's reference, which seems to suggest that she cannot. But this is where we get into the sticky situation of will Brown or Wilson be followed? So if Brown was followed, Jo would have no defence because it's not in the public interest for people to be doing things like this for sexual gratification. However, the case appears on the facts to be more similar to Wilson, perhaps, because it's a case involving a heterosexual couple and a branding. And in the case of Wilson, consent was available, and the court compared the branding as being similar to a tattoo. So we could apply that rationale here to Anne. So in conclusion, if we follow Wilson, which seems the most likely option here, Jo's likely to succeed with the defence of consent. So it seems that that defence may be successful for him. But it's always good, as you can see here in the application, to say that we've not got a definite answer. If Brown was followed, this would be the outcome. However, it seems more similar to Wilson, so therefore we think the defence will be successful. Thanks for watching. I hope that video was helpful to you in understanding how you should go about applying the defence of consent to a scenario. I do have a video on my channel that looks at how you should evaluate the law on consent if it comes up as an essay type question. And that's a really interesting one, actually. As you can tell probably by the contrasting cases of Wilson and Brown, there's lots to delve into there. So you might like to watch that video as well. Please do subscribe if you've not already and like the videos on my channel because it does really help me to make new content for you.